to everybody. Today we are going to be discussing the ECtHR's Yalçınkaya decision. We have with us Dr. Sanna Elfving and Dr. Chloë McRae Gilgan, both senior lecturers from the University of Lincoln Law School. Thank you and welcome. May I kindly ask you to, just briefly introduce yourselves for the audience who do not already know you?
Sure. I'm Dr. Chloë Gilgan, and I'm happy to have contributed to this policy brief. As you said, I'm a senior lecturer at University of Lincoln in international human rights law. And my colleague here.
Hi, everybody. My name is Sanna Elfving. I am also a senior lecturer at the University of Lincoln Law School, and my special expertise is the European Court of Human Rights and EU law.
Thank you. There is much talk about the Yalçınkaya decision, and what is it exactly, and why is this decision so important?
Yeah. I don't mind taking the first question, just because I think on some of the more detailed aspects, Sanna will be an excellent person to comment on those. But overall, I think the decision is very pivotal for two broad reasons. First, in terms of its substance, and second, in terms of its impact. So first, in terms of substance, the court meaningfully upheld human rights by making clear that individual liberties must be better balanced with national security, and that the latter, that is national security, does not trump human rights even in times of political emergency. So the court's ruling marked a pivotal moment, particularly concerning convictions related to the Gülen movement in Turkey. The judgment highlighted a systemic violation of convention rights, particularly Article 7, which embodies the principle of no crime and punishment without law, and then Article 6, which is the right to a fair trial. And then second, in terms of impact, this means that the thousands of similar cases are likely to also result in unlawful violations of European Convention rights that were found in this judgment. So some numbers here. At the time of the judgment, there were approximately over 8,000, somewhere around 8,500 applications on the court's docket involving similar complaints under the right to a fair trial and to no punishment without law, respectively. And it was based on the same information that the authorities had identified around 100,000 so-called Bylock users, which is an app. Therefore, the ruling is going to have profound impact on those individuals already wrongfully convicted under the same factors, but also those yet to be prosecuted, so in various stages. So it will have a huge impact on many of the people suffering these same violations.
Thank you. And you mentioned Bylock, and what is it exactly, and how exactly Turkey violated the convention with regards to its handling of Bylock evidence as evidence of terrorist activity?
Right.
Sanna, do you want to answer that one, or do you want me to answer that?
I can answer that one, thank you. So Bylock is an encrypted messaging application which the Turkish authorities considered to be linked to the Gülen movement. So anybody who would have been using it was potential suspect of these terror offences. And this Gülen movement obviously was considered to be behind the attempted coup on the 15th of July 2016, because allegedly some of its members had infiltrated Turkish armed forces. And in terms of handling the Bylock messaging app as evidence of terrorist activity, the court found violation of Article 7, no punishment without law, and Article 6, right to fair trial, because the mere fact that individuals were using the Bylock app was over-relied upon as evidence of both intent and commission of terrorism. And this violated Article 6, the right to fair trial, because the over-reliance on the use of Bylock is as an indicator of criminal intent and conduct was irrespective of any incriminating content. So individuals could have been sending any kind of messages on Bylock, anything to do with, hi, can I see you tomorrow? Let's go for a picnic. Nothing to do with to necessarily substantiate any intent to commit acts of terrorism, and that is a problem with this judgment, that those messages were used against people without really looking at what were they actually communicating in those messages.
I just want to go into this no punishment without law. I mean, what is it exactly, and how did the court find that Turkey violated this particular Article 7?
Okay.
Shall I take that one, or?
Yeah, you go ahead and take that one.
Okay, great. So thank you. So Article 7, no punishment without law, is it safeguards individuals' rights against prosecution that is going to be detrimental to them. And in this particular case, the Turkish authorities were dealing with an aftermath of an attempted coup, and they were using the fact that there was a state of emergency declared and obviously then renewed to violate Article 7, even though the European Convention on Human Rights allows a derogation in times of war or other public emergency. It explicitly forbids derogation of Article 7. And about the content of Article 7 a little bit, I can explain to you that it requires that an offence has to be clearly defined both in written and unwritten law, so for instance legislation, and then if it's drawn from case law, for instance, it needs to be clear for the perpetrator or the accused person, so that they know that some activity could result in prosecution if they breach those laws. Similarly, Article 7 requires that a personal liability has to be established in the conduct of the person who physically commits the offence. So, for instance, terrorism acts or acts of terrorism, there needs to be a clear intent to commit some form of violence or threat of violence. And even though the crime is clear, the commission of terrorism acts is clear under Turkish domestic law, it was sufficient. It was insufficient to use the mere use of Bylock as evidence, because the domestic courts failed to establish that all the requirements of the offence had been fulfilled, particularly the necessary intent. And under established case law of the domestic courts, there had to be proof that Mr. Yalçınkaya had acted knowingly and willingly within the organization's hierarchical structure and embraced its objectives. And this was not met, as the Turkish courts had equated the mere use of Bylock with Mr. Yalçınkaya knowingly and willingly being a member of an armed terrorist organization. Therefore, his conviction was secured without establishing the presence of all the constituent elements of that offence in an individualized manner. in contravention of the requirements under domestic law, the principle of legality and foreseeability that is at the core of the protection under Article 7. And there was no other evidence to support the presumption of him being guilty, because the content of the messages or identity of the persons with whom the exchanges have been made were not considered. And such an expansive interpretation of the law made an automatic presumption of guilt based on the use of Bylock, making it nearly impossible for Mr. Yalçınkaya to exonerate himself on the accusations. So the scope of the offence could not have foreseen by Mr. Yalçınkaya, which obviously contravenes the purpose of Article 7, which is to provide effective safeguards against arbitrary prosecution, conviction, and punishment, as the offence of membership of an armed terrorist organization under Turkish law is an offence of specific intent. Then the necessary condition of that specific subject element are present. Sorry. Yeah. So, and in necessary condition is that specific subject elements are present.
Yeah.
So it is necessary for an organization which is accused of being involved in terrorism to commit crimes by the use of force and violence, whereas an act of subscribing to a form of ideology and sharing ideas or getting together with other people to cultivate an interest in an ideology is not sufficient to qualify as terrorism.
Would it be correct to say that, you know, the Turkish court in that case has never identified or established the mental or the physical elements of a crime, and it held sufficient that the fact that you know, allegedly Mr. Yalçınkaya allegedly downloaded this messaging app was enough to convict him of a terrorist offense? I think would that be a fair summary of what it said in relation to no punishment without law?
Yes.
Yeah. Go ahead, Sanna.
Sorry. They also indicated, the domestic courts indicated that they took into account the fact that Mr. Yalçınkaya was a member of organization to do with educational, something to do with trade association and educational association, and he also had a bank account with a specific bank, but they denied that these were actually decisive. So it only left then the mere use of the app as a decisive indication of commission of terrorism.
Yeah. So Gilgan, is it? Would you like to add something? I think you would.
No, I think that was it. It was just I think
yeah.
I think what you said was absolutely right. And I think it kind of brings us sort of to the next question about, you know, the actual other violation here, which was about the applicant's right to a fair trial, right? Because the court was not even looking at the content of those messages, right? So there was a violation. The court found a violation of Article 6, which is the right to a fair trial, because there were insufficient safeguards, basically, to ensure that Mr. Yalçınkaya had a genuine opportunity to actually challenge the evidence against him and then conduct his defense in an effective manner and on equal footing with the prosecution, right? So this essentially the raw Bylock data that was collected by the intelligence services was not shared with Mr. Yalçınkaya, which prevented him from challenging the validity of the inferences that were drawn from the use of that Bylock app data, right? So, so it was just the mere possession of having this app, right? And the domestic courts had also refused to submit the data for an independent examination for verification of its contents and integrity. And there were also concerns over the reliability of the data, such as the inconsistency between the different Bylock user lists that were issued by the intelligence services and the number of users identified and eventually prosecuted. There were even further deficiencies, included the fact that Bylock had been downloadable publicly and publicly available, you know, in stores and sites until early 2016, and for 2 years before without any monitoring at all. So very, very broad sweep to you know, infer criminal conduct and intent just from mere possession and use of an app. So therefore, you know, essentially it was possible for anyone to use Bylock, not just members of the Gulen movement. And the domestic courts failed to explain that. And also the Turkish courts and the government failed to explain why it was even necessary or whether there was a genuine and proportionate response to this emergency situation that could result in a valid limitation to Article 6. As derogations under Article 15 of the European Convention or Article 15 of the Turkish Constitution. So there was no valid limitation or explanation for derogating. So absolutely, you know, I would say we agree, as you brought up, with the decision, and particularly on this aspect as well, is that an essential component of democracy and upholding the rule of law is to allow even society's potentially worst perpetrators a proper defense. And that means there has to be evidence and substantive evidence to be presented to the defendants so that they can mount a robust defense that confronts the evidence against them. And we can all, I think, relate to the injustice of being blamed for something we never did, but it is made even worse when there's no real evidence presented to us so that we can actually clear our names. And then we should also mention, and I think Sanna talked about this a little bit, is that the court also found a violation of Article 11, freedom of assembly and association, because the judicial authorities' reliance on the applicant's membership in a trade union and an educators association, which of course was most likely related to his work as a teacher, a very common thing to be part of a union and maybe a credit union. But they use that as sufficient to constitute an interference with his rights under Article 11. Now, membership was used as an indication of criminal conduct, despite the fact that it was operating legally prior to its dissolution by national legislation on the grounds that such organizations posed a national security threat due to their alleged affiliation with the Gulen movement. The courts had not explained what the organizations had done to bring about their dissolution, and they had not assessed whether Mr. Yalçınkaya's membership of them had actually involved, and this is taken right from the law, quote, inciting violence or otherwise rejecting the foundations of a democratic society, end quote, and that was found in the case. So, you know, essentially what we're seeing is something as common as being part of a teachers' union and a credit union was also used as evidence of criminal conduct. Again, lack of any actual criminal conduct, content or evidence is problematic, right? So it all goes back to just using this app as an indicator of intent and criminal conduct. So I just wanted to add that. I know it sort of moves us forward, but
thank you. And the court pointed out certain systematic issues regarding convictions based on Turkey's anti-terror laws. And what sort of systematic issues did you identify in relation to that?
Yeah.
Shall I take that one?
Sure.
So yes, so there is potential implication of this judgment outside Turkey as well, because there are other countries which have been criticized for using terror laws that are too wide and unspecific. So in this regard, it's an important judgment for the court to be issuing. A significant aspect of the ruling was was made under Article 46, whereby the court ruled that Turkey must take measures to address the systematic over-reliance of the user's position of the Bylock application as an indicator of criminal intent and conduct, irrespective of any criminal content. And there's likely to be thousands of pending cases that are going to result in the same sort of outcome. So there will be unlawful violations of the European Convention on Human Rights that were found in this judgment, and it has been the systematic issues of Turkish human rights record have been highlighted in the past by a number of different entities. For instance, the European Parliament in 2022 highlighted that the application of terrorism charges and restriction of freedom of expression are deliberate and systemic government policy designed to suppress critical or dissenting voices, including lawyers, academics, journalists, and rather than seeing these individuals as valuable contributors to social dialogue and allowing professions to exercise their profession freely, Turkey has decided to suppress these voices, and this is not healthy for the democracy or the society overall. There's further sort of further condemnation of Turkey's approach. For instance, the Parliamentary Assembly of the Council of Europe has started a full monitoring procedure, which is aimed at addressing some of the serious violations concerning the respect for human rights, democracy, and rule of law, and they will keep this monitoring procedure open until Turkey has addressed these issues in a satisfactory manner. And there are issues with the Turkish judiciary or the independence of Turkish judiciary as well, because there has been some changes in terms of appointing judges to the courts, and there seems to be some element of trying to influence the judges politically, whereas to keep judiciary and the political arm of the government is paramount to ensure democracy and respect for civil liberties. So this case makes very clear that individual liberties must be better balanced with national security, and that national security cannot trump individual liberties in the times of political emergency. Another body, the Venice Commission, has also found that there are concerns that remain about continuing erosion of rule of law and judicial independence and impartiality in Turkey, coupled with the dismissals of the members of the judiciary, which undermine the judiciary's independence, impartiality, and overall capacity to provide an effective remedy for human rights violations.
Thank you. Dr. McRae Gilgan, would you like to add anything to what Dr. Elfving was saying?
Well, I think it just brings us, round to the sort of important question of what does Turkey need to be doing in order to fully comply with the decision. So I don't really have too much to add to what Sanna said, except in that kind of context is that, the court made a point of noting that Article 46 of the European Convention on Human Rights holds the force of a constitutional rule in Turkey. So according to Article 95 of the Turkish Constitution, international human rights treaties also must be granted preferential treatment over domestic law. So this is really important, and this sort of highlights and builds upon what Sanna was just talking about. So essentially, Turkey must implement the judgment. It does risk, if not, it does risk exacerbating its declining relationship with the Council of Europe, right? And that's really, really important. So some of the specific things that Turkey must do to fully comply with the decision would be, first off, as we've sort of just bringing together what we've said during the interview, is just that it needs to clarify the elements of a terrorist offence in terms of making it foreseeable and compatible. And it's too vague and overly broad, allowing for sort of these abuses of human rights. They also need to cease the use of Bylock as an indicator of criminal intent and conduct, right? Retrials should be undertaken for those individuals that were convicted based on their use of Bylock without any other substantive evidence of intent or conduct that rises to terrorism. There should be a disclosure of the electronic data that's being used against these defendants, along with any exculpatory evidence, including deleted data, all of this in the name of due process. And then also authorities must make sure that the electronic data is reliable and fair by disclosing the reasons for any time gaps, and there should be transparency in the chain of custody. All of these things go to a fair trial. And then more broadly speaking, I think, as Sanna was just talking about, that Turkey needs to address the systematic issues at the root of its persistent human rights violations, and essentially by bringing Turkish law more in line with the European Convention, as Sanna mentioned, was noted by the Venice Commission. So, just even broadly, this means strengthening its democratic institutions, such as a more independent judiciary, and more specifically, the judiciary should be appointed by peers rather than political appointment by the president. And then, of course, also fixing overly vague anti-terror laws through redraft and maybe even potentially some repeal of some of those laws. So I guess that's pretty much what I would add to it. But a very important case that will have impact. And I think something Sanna said, which was very important, is this has impact beyond Turkey, because it's not the only state that has overly vague or broad anti-terror laws. You can even see that in some Western liberal democracies as well. So I think in terms of the impact is very much on all Council of Europe members. So very, very important case.
Thank you. Thank you very much indeed for being with us today, Dr. Sanna Elfving and Dr. Chloë McRae Gilgan. As you said, this is a pivotal case, and we will continue to monitor which steps are being taken to ensure the implementation of this crucial judgment. And I think that concludes our interview today. Thank you very much indeed for being with us, and hope to see you in the not so distant future. Thank you.
Thank you so much.
Thank you very much.